Hi again, everybody. This is Mark Mavsessian. I'm the director of the Mattone Center for Law and Religion at St. John's Law School in New York. And this is another episode of Legal Spirits, our podcast series on cases and issues in law and religion. You can find past episodes archived on our website, lawandreligionforum.org, and also on streaming platforms like Apple iTunes and Spotify and Android. If you like us, please subscribe so that you can be alerted when new material becomes available. Well, in this episode, we're going to discuss an important church and state case from Oklahoma. The case is called Drummond versus Oklahoma Statewide Virtual Charter School Board. It's a long name. And it involves a charter school called St. Isidore of Seville Catholic Virtual School. Now, as the name suggests, St. Isidore is a Catholic school that incorporates Catholic teaching into its curriculum. The state school board entered into a contract with St. Isidore to operate as a charter school. But last month, the Oklahoma Supreme Court ordered the board to cancel the contract. The contract, the court said, violated both the state and federal constitutions. The Oklahoma Constitution, which prohibits public money from being used directly or indirectly to benefit a religious institution, and the U.S. Constitution, which prohibits the establishment of religion. The court also rejected St. Isidore's argument in the alternative that canceling the contract with the school board would violate the school's free exercise rights under the U.S. Constitution. This is an important case. Charter schools are a way of overcoming the abysmal condition of many public schools in the U.S., but they're controversial, mostly because of their hybrid private-public status. And mission-driven, religiously affiliated charter schools like St. Isidore, which offer a lot of promise, are especially controversial because of anti-establishment concerns. So I wrote last month on the Volokh blog that the Oklahoma court probably decided this case correctly as a First Amendment matter. But my friend Rick Garnett disagrees. Now, Rick is the Paul Skirl Fort Howard Corporation Professor of Law, a concurrent professor of political science, and the director of the program on church, state, and society at Notre Dame. And it's no exaggeration to say he's one of the most important church and state scholars of his generation, our generation, I guess I'd say. What he says carries a lot of weight. And so I asked him on Legal Spirits to discuss the case, and he graciously accepted. So in this episode, we're going to discuss the legal issues raised by this case, and then if we have some time, some policy questions at the end, too. So welcome, Rick. Thank you so much for coming.
Thanks, Mark.
So listen, by the way, I should mention straight away that the Notre Dame Religious Liberty Clinic, I believe, is representing St. Isidore in this litigation. But Rick, you're not involved in that case, right?
I'm not involved. My wife is.
Okay, all right. Well, she's, as you always say, the better half of the Garnett couple, right? So, but anyway, you're not involved in this, but I do want our listeners to know that the Religious Liberty Clinic is involved, and I guess Nicole too. Okay, so Rick, St. Isidore is a charter school. So first, let's talk about what that means, because it's kind of a nebulous concept. So what does it mean to be a charter school?
Yeah, you're right. It's a nebulous concept, and it's also a concept that varies from place to place. But the way I think about charter schools is that they are contractors. They are schools that are run by non-government entities often, but they are doing so under a contract with the state. So just as the state contracts in many contexts with private outfits to, pick up the trash, or here in Indiana, we've got a private contractor that runs the toll road. Charter schools provide education, and they are paid for with public funds, but they are not operated under the same rules and conditions and constraints and requirements that state schools, government-run schools, traditional public schools are run. They often have more flexibility, Mark, as you know. They came into being as a way of letting some schools experiment with policies and practices that, maybe the union agreement wouldn't permit, or maybe that wouldn't work for an entire district, but it was a way to introduce some diversity into public education.
Yeah, so this is interesting, Rick, because of course this is the first issue in the Oklahoma court's decision. The Oklahoma court, and I should say it was a 6-2 ruling. There is a dissent. There are 2 dissenting judges, but only one judge wrote a dissent in the case. The other dissented without opinion. And the first thing that the Oklahoma court said is, well, actually, a charter school is not a private actor. It's a public school. And Now, the Oklahoma court put a lot of weight on the fact that the Oklahoma statute itself, the charter school statute, the enabling statute, refers to charter schools as public schools. And, I have to say that struck me as a pretty serious argument. The dissent says that's just form over substance. So why don't you address that particular element?
Yeah, no, I'm with the dissent on that one, but I think you're right. That's a good talking point for the majority's position. Um, let's think about what it would mean if the constitutional question about whether or not an entity is a state actor could be determined just by a legislative declaration in a statute. I mean, as you know, it's pervasive in American life for the government to partner with non-state institutions and to send non-state institutions public money. Think about Medicaid, Medicare, the GI Bill, and so on. And it seems to me that if Congress passed a law, just sort of said, hey, by the way, we're declaring that any entity that receives any public money is now part of the government, that wouldn't carry much constitutional weight in terms of whether the Establishment Clause has been violated or whether some other state action uh, um, rule had been triggered. So it's actually it's much more complicated. And our argument is that given the particular way that Oklahoma's charter school regime is structured, that these schools, again, they're contractors. They're not part of the government. Their hiring is not controlled by the government. They are free from nearly all of the regulations that apply to government schools. They're delivering a service that the government wants, that we all, as the public, want. But the Constitution applies to state action, to the government's own actions. And our view is that the actions of St. Isidore and its employees would not appropriately, as a constitutional law matter, be regarded as state action. And so, therefore, we think, and by we, again, I don't represent the school, but I'm the royal we, maybe. Um, we don't think that the Establishment Clause principle has been violated. We totally agree, that is, you and I agree, Mark, that the government can't run a Catholic school. I think that's pretty clear. So the position of St. Isidore depends on the premise that St. Isidore is more like a contractor than it is like, you know, the city parks and rec department. And therefore, as long as St. Isidore is delivering a public service, which it is, it's perfectly appropriate for it to receive public funds to deliver that public good. And we think it can carry out this in a mission distinctive way, because that was initially the theory of charter schools to begin with, that there could be pluralism and diversity in the delivery mechanisms.
Yeah, Rick, I always want to say so. So I take your point about you can't just stick a label on something in a statute then determine the essence of the thing. But if I understand it correctly, I mean, you say there that St. Isidore and other charter schools are exempt from almost all regulations, but they do talk. If I remember correctly, the majority says the Oklahoma majority says, the teachers are subject to the same licensing requirements, and I think one of the key distinctions between private and public schools is precisely that. So is that not correct? Are they not subject to the same licensing requirements?
Well, there's two layers to that. So one thing is to remember that the state has the authority to regulate private schools in many ways. So it's not the case that the relevant line is totally unregulated versus regulated. Every educational institution in Oklahoma, or indeed anywhere else, is subject to some regulations. So there are states that have kind of uh, licensing or credentialing requirements for teachers that are in non-state schools. That's not unheard of. My position would be that a rule like that is different from saying that St. Isidore is itself part of the government. Being regulated doesn't make you part of the government. Being funded doesn't make you part of the government. And the Establishment Clause only applies to the government, or at least that's my view.
Yeah, I see. No, no. Okay, so let's set that issue aside. Although I think it is an interesting issue here, and let's move on to what I think, in some ways, is more interesting because it tracks what the Supreme Court has been saying in some more recent cases, and that is, let's assume, for the sake of argument, and we should say that Saint Isidore makes this argument too. Let's assume, for the sake of argument, that you're right, that Saint Isidore is a private school. Then the argument is that by excluding Saint Isidore from this program, in fact, Oklahoma has violated the free exercise clause of the Constitution by interfering, or by, I guess we'd say, placing a substantial burden on the free exercise of religion by this Catholic school. So, what's St. Isidore's free exercise argument?
Yeah, and you're really you're right on target, Mark, by connecting this to some things that have been going on in the Supreme Court lately. Um, in a series of cases, kind of a trilogy in the last few years, a case out of Missouri, a case out of Montana, and then a case out of Maine. Um, the Supreme Court has affirmed and then reaffirmed and then triple affirmed the idea that once the government opens up a program and permits non-state entities to provide a public service, to participate and to receive public funds, it can't then discriminate against religious providers when it runs that entity. So no one is saying that Oklahoma has an obligation to fund Catholic schools. That's not the claim. That wouldn't be correct. But the claim in those other Supreme Court cases, which the Supreme Court endorsed, is that once a state says, hey, you know what, we're willing to partner with non-state schools in order to deliver this public good of education. Once they say that, they can't then say, oh, but only if you're not religious. So that was our argument, was that, Oklahoma invoked its own state law to say, well, we're not allowed to fund any religious schools. Now, we think they're wrong about state law, too, to be honest. But even if that were true, then that just means the state law is inconsistent with the federal First Amendment, because that provision now, the free exercise clause, as you mentioned, has been, we debate about a lot of things in the free exercise law, but one thing that's pretty settled is that government can't impose burdens or discriminate simply on the basis of religion. And so I would argue that if Oklahoma's reason for excluding St. Isidore from this whole range of other contractors they're willing to do business with, if their only reason for excluding St. Isidore, which qualifies in every other respect, is that it's religious, well, then it's violating the non-discrimination rule. And so maybe this is going to be part 4 in the Supreme Court's continuing series on the anti-discrimination principle.
Yeah, now let's actually be a little more detailed about that, because, and you can correct me if I'm wrong, but I think cases like Espinoza and Carson, and listeners, these are the Supreme Court cases that Rick and I are talking about. What they say is, if there is a substantial burden on free exercise, then the state has to pass the compelling interest test. And what they'd say is that the state doesn't have a compelling interest in denying public funds to going to religious schools on the same basis that it gives funds to non. Is that about right?
Yeah, and I apologize if this is too far in the weeds. I think when we're in the context of talking about the non-discrimination principle, I like to distinguish that from the burden principle. When you're talking about burdens, in my mind, that's the question we ask when people are seeking an exemption from a general law.
Mm-hmm.
But that's not really what's going on in this series of cases, and I don't think that's what's going on in the Isidore cases. This is just a case, as St. Isidore frames it, of discrimination. And discrimination, the court has been really clear, is just a per se burden on the free exercise clause. But then you're right, Mark, that what follows from that is that the court then asks, well, does the government have some kind of compelling interest that might justify this differential treatment? And, one potential compelling interest would be, well, the federal Constitution requires us to do this. But my view would be that it doesn't, because, as you know, for now going on a quarter century, the Supreme Court has said that programs like school choice in Ohio and other places are permissible, that it is permissible for governments to partner with religious institutions in order to deliver social services like education and healthcare and so on. So what would be the government's compelling interest in singling out religious schools for exclusion? In the past, governments used to argue, well, here's our compelling interest. We want to have a stricter separation of church and state than the one that the Supreme Court requires. And there's a history to that argument. But the Supreme Court, I think, has pretty clearly in these last 3 cases that we've talked about rejected that and said that a state's desire to be more separationist than the federal Constitution requires, that's not a good enough reason for discriminating against religious schools. This is it's a federalism question in a way, right? The federal free exercise guarantee trumps a state's policy choice to have a stricter separation.
Right. So just so listeners, so Rick mentioned three cases there. We talked about Espinoza and Carson. The third, I guess, is Trinity Lutheran. Is that the one you're thinking of, Rick?
Yep,
Right.
yeah.
Which involved, I guess, playgrounds at a church. Was it a school in Trinity Lutheran?
It involved recycled, chopped up recycled tires for playgrounds at a Lutheran preschool.
Okay, preschool. All right, so that's the third one. So now, Rick, let's get into the issue that you and I were discussing on Twitter a little while back. So in these cases, like Espinoza, let's just stick with Espinoza and Carson, which I think really are on all fours with this case in a lot of ways. Um, what they said is that it is permissible. It's not an establishment clause violation if the state gives out money on an equal basis to parents, and then the parents themselves decide through as a matter of private choice that they will spend the money on religious schools. It doesn't make a difference if it's religious schools, if it's non-religious schools, it's up to the parents. And it seemed to me that that doesn't really happen here because it's not a question of parents paying tuition and the state gives the parents the money. These are free, these schools. Charter schools are free. The parents are not paying tuition. This is direct funding to the schools. And the way I said it was without the filter of private choice. And on Twitter, you said, well, no, there is still a filter of private choice. So why don't you explain your position there?
Yeah, and this is important, Mark. You're right that you know the reason why school choice is permissible, according to the court in this Zellman case 25 years ago, is that at the end of the day, the reason why public funds end up at the parochial school is because the parents are deciding to take their education benefit and put it over there as opposed to over here. And the court's reasoning was, well, that means it's not an establishment of religion. It's just like if somebody who works for the post office takes his salary and donates it to the Little Sisters of the Poor, that's not an establishment of religion. That's his choice to do what he wants to do with his money. Um, now, my argument would be that we don't want to fixate too much on the details of the financial delivery mechanism. Like, for instance, it's not the case that the government has to come and drop a sack of money on the parent's desk and the parent has to physically take it over to the parochial school for things to be fine. It's the way vouchers work is not like that, right? I mean, the money actually does flow through bits and bytes in space into the bank accounts of the school without any kind of physical intermediary. I would, what you and I were talking about on Twitter, and I think you've really honed in on a crucial question. I want people to know this. St. Isidore Charter School gets no public funds unless a parent chooses to send a kid there.
Okay, now explain the mechanism, Rick, because that's an important point you're making. So how can that be the case?
Yeah, yeah, they are funded only on a per
Mhm.
capita basis, right? And the court has upheld that kind of delivery mechanism in a case it was actually before Zellman called Mitchell versus Helms, where the court said, look, if the funding mechanism is per capita, then it's still the case that no money gets to the charter school except by virtue of parents choosing to send their kids there. So, this is kind of different if you think about it than some traditional public school districts where the district just gets money, and if whether the kids kind of show up or not, they get the money. That's not true of St. Isidore. Its money is determined on a per capita basis, and so my position would be that that's for all practical purposes the same thing as again handing a parent a check and saying go spend it where you want. This is just kind of, again, it's in the modern world, it's the way money
Yes.
gets delivered. So I think the Zellman principle is respected here, and that insofar as we think indirect funding really matters, this still is indirect, even if the ones and zeros travel directly. For establishment clause purposes, the parent's choice is still the driver.
Yeah, so I guess if we're really going to go there, so I guess, Rick, this is a form versus substance argument. You're making a substance argument. This is all the same. And I'm sort of saying, well, the form is different. And doesn't that make a difference? But just to be clear here, so the school year begins and there are 20 students. St. Isidore gets funding for 20 students. And if the school year begins with 15 students, it gets funding for 15 students. Is that how it works?
Yes. Yeah. Now I want to be. Let's be clear on this. Different states have different charter funding mechanisms. So there are some states, for example, where there's like capital costs that get treated specially, and there are some states where the amount of funding that a school gets is different. Like if the kid goes to the traditional public school, then X $1,000 follows the kid. But if the kid goes to a charter school, it's less. So this varies from place to place. I don't want to mislead your listeners on that point. But in Oklahoma, uh, I think it's pretty clear that the money only gets to St. Isidore or to any other charter school, many of which are run by non-state entities. Some of them operated by for-profit businesses. They only get the money if the kids show up.
Yeah, that's really well. That's very interesting. That could make a difference. It just depends on how much emphasis you want to put on the form. So Rick, let me move a little bit to the policy question, which I find interesting because when I read this, one thing jumped out at me in the opinion, in addition to all the other things we're discussing, and that is Oklahoma does have a voucher system.
Yeah.
And it seems to me that St. Isidore could have avoided all these problems if it just said, okay, we're going to participate in the voucher system. And so is it just a matter of the amount of funding that is just much better in a chart? Why did they choose to go this kind of problematic way?
Yeah, and so I'd be over my skis if I tried to speculate on that. I genuinely don't know. And as you said at the top of the show, I'm not representing St. Isidore, and so can't speak for them. But uh, one way to think about this, at least in my opinion, is you can put it in this broader context of kind of different policies that are in place and that are really taking hold in a lot of states right now that are designed to kind of give parents more choice in terms of where their kids get educated. And this was picking up before COVID. COVID really launched it, but there's a whole bunch of different ways to do this. So you mentioned vouchers. That's a traditional method. A lot of states have had tax credits or tax deductions. A new mechanism that people are really interested in is education savings accounts. Um, in my view, these are all really good. And there are some people who are supporters of school choice who prefer those mechanisms to charter school type mechanisms. And that's an interesting debate to have in the education reform community. Um, I support education savings accounts and school vouchers too. I don't regard this as an either or. But it could be, and again, I'm not speaking for St. Isidore, that it's easier for parents to navigate a charter school system than it is to navigate an ESA, education savings accounts, or a voucher. It could be that in some states the dollar amount is different. That the funding that comes with a charter is greater than the funding that comes with a voucher. In places that have vouchers, it's almost always the case that the voucher is way less than the per pupil spending that the traditional public schools get. So I'm actually kind of, I wouldn't say agnostic, but I'm kind of open to lots of arguments about which policies are best in order to operationalize this kind of broader principle of school choice. And the more of them, the better, as far as I'm concerned. Some people are concerned, you and I both know this, that the charter school route might be dangerous because maybe there's more regulation attached to charter schools than to, a kind of traditional, say, parochial school. I hear that concern. If I were thinking about setting up a school, I'd want to make sure that I had the freedom to operate in a way that was consistent with my religious mission. And I'm a Catholic myself. I would regret it if charter schools kind of crowded out traditional parochial schools. I think that'd be a bad thing. But St. Isidore's is occupying a particular niche that a voucher program couldn't have satisfied. I don't know, Mark, if we've talked about this before, but St. Isidore's is online, and it's catering primarily to rural kids, and often low-income rural kids, who are outside the reach of any kind of traditional parochial schools and so on. So they wouldn't be able to use a voucher,
Yeah, that is interesting. No, we hadn't talked about that. I did notice that the name is virtual. Virtual's in the school, in the name. Sorry.
Yeah, yeah. So it's interesting. It tends to be kids who are low income and rural, and that's kind of where they're aiming. If you have I live in South Bend, Indiana. We're not a huge town by any stretch, but we've got a network of parochial and private schools, and so we're able to kind of have a kind of diverse ecosystem of education that can tap into our school voucher program. But in some parts of Oklahoma, they don't have that infrastructure built up, and so a charter school, a virtual online charter school, is a way to fill a gap that might otherwise not go filled.
Yeah. So last question. Thank you. That's very interesting. Last question I want to talk about is so I had a student write a note about this case, and this is something that he was actually sort of sticking on, which is, well, I mean, what happens? Okay, we have Saint Isidore School. What happens when the Satanists, as a stunt, or maybe they genuinely believe this, they want to have their own Satanist school, right? And so now, how do we get past that issue? Now, if it's just a matter of, okay, we give the money to the parents choose this, we can sort of live with that, the student was saying. But I really don't want a charter school which is getting direct funding. So I mean, now look, there are people like Hadley Arcus who say we just shouldn't be neutral about this stuff. Let's just have a principle that says Satanists don't get this. But how would you address that issue?
Yeah, as I think you know, I mean, this is a it's a broader principle, right? It's a principle that kind of goes to the heart of a lot of our free speech doctrine. Um, in the United States, for better or worse, our free speech doctrine really does lock into this idea of viewpoint neutrality, which inevitably means that there are some viewpoints that at least I find really offensive, obnoxious, or worthless still get protection. And in my view, the Satanists are kind of an unpleasant bunch. I think they're, truth be told, I think they tend to be mainly kind of tricksters and trolls, but that's a separate question.
Mm-hmm.
But yeah, it's true. Like, once we open up the educational space to non-state cooperators, then it's going to follow that you can't kind of pick and choose too much on the basis of whether you like them or not. Now, but it doesn't mean it's the Wild West. I mean, in any charter school regime, and also, frankly, in any voucher regime, you can have all kinds of requirements to ensure the quality of the education that's being delivered. Now, again, I'm not a big fan of a Satanist school, even if they're teaching the kids math really well. But um, I think sometimes there is this straw man, and frankly, in Oklahoma, the officials who were opposing Saint Isidore were drawing on this straw man a lot. Like, oh my gosh, this is going to mean terrorist madrasas in Oklahoma. That strikes me as kind of unlikely. And also, it's a little, to me, unsavory. Like, yeah, you know what? If some Muslims want to set up a charter school that meets all of the requirements, well, I mean, American religious freedom law does not permit denominational discrimination.
Mm-hmm.
So in a sense, your student is tapping into an important question that, again, once you open up a free speech market or an educational diversity market, you're taking a chance that there's going to be some schools that are teaching kids stuff that you don't like. But there are guardrails, and I think the government is well within its rights to set up those guardrails in terms of educational quality, test scores. Um, the original school voucher program in Ohio that was upheld in the Zellman case, which you mentioned, Mark, they had a rule that said something like the school couldn't, deny equal citizenship or teach hate or something like that. And the courts have never had to really evaluate those requirements, but things like that probably wouldn't be uncommon. So I'm a big fan of slippery slope arguments. It's always worth being careful about that kind of thing. But I think those concerns are not weighty enough, given all of the guardrails, to warrant closing the door on this particular education reform mechanism.
Okay, well, great. I think that's a good place to end it. Listeners, you can decide for yourselves. Rick, I want to thank you. This has been a great episode. You really hit all cylinders, and I think our listeners are going to learn a lot from this. I certainly learned a lot from it too, so thank you very much. But listeners, that's it for this time. So this has been another episode of Legal Spirits, which is the Mattone Center for Law and Religion's podcast series on cases and issues in law and religion. You can find past episodes archived on our website, lawandreligionforum.org, and also on Apple iTunes and lots of other streaming platforms. So please subscribe so you can be alerted of new content as it becomes available. But that's it for now. See you next time.